Hi, Favor. Okay, thank you. Can you make me a co-host now? So let me tell these guys that the meeting room is open.
Expertise, dedication, passion to every transaction. And I'm sure that today will feel this passion as I invite our speaker to kick off this session, Consortium Agreement.
Please, can the host unmute the speaker? Ayodeji Bruce.
Okay, apologies for that. So host right was just returned to me. I will unmute her right away. I'll make her a
Thank you.
co-host again. I think she probably got logged out at some point. Okay,
Yes.
now she's a
Thank you.
co-host.
Yes, I did. Thank you so much, Damlola. Thank you, Ayodeji. Thank you, everyone, for this opportunity. I think I should start by apologizing for the technical errors that I'm currently experiencing. I don't know what's going on with my camera, but for some strange reason, I'm unable to see myself, even though my camera is on right now. So I want to sincerely apologize for my inability to show my face on this um, at this discussion this afternoon. Apologies to everyone on the call. Thank you so much for this opportunity to speak to everyone on the topic drafting and reviewing of consortium agreements. I'm not going to say much. I've been introduced by Deji, and I was wondering that is Deji introducing me or somebody else because the introduction seems to be quite long. But thank you so much for the opportunity, and I think I'm ready to shoot once I see my slides on the screen. I think Deji will be assisting with that. Good afternoon, everyone. Okay, somebody say something about shorter. Yes, I think I'll just proceed with this um, presentation. Okay. Okay, Deji, please, can you just go to the... Okay, thank you. Okay, so thank you, Deji, and I'll just be giving you the cue as to when to move the slide. So I'll just be speaking again on drafting and reviewing of consortium agreements this afternoon, and the outline as showing on the screen right now. I'll just take us through a brief introduction and overview of consortium arrangements in the oil and gas sector as they use in the oil and gas sector, overview of consortium arrangements, purpose and necessity for consortium arrangements, then drafting considerations, which is really, really the reason why we are here, negotiation considerations, and then some key takeaways. So that's just a brief outline of what the presentation will look like. Ayodeji, so I didn't see Ayodeji now, or Deji work. Okay. So what's the learning objective for this afternoon? I think just basically at the end of this discussion, I think we should be able to have a brief understanding or a fair understanding of the nature and purpose of consortium arrangements in the Nigerian upstream oil and gas sector, identify some key drafting consideration and common errors. And I call them common errors because I think in some of a couple of transactions that I've had the privilege to sort of advise on and review, one agreement or the other. There's some errors that you just see cutting across, when people are, drafting this agreement. So I'll be, speaking on a few of those errors that I've seen. Then, of course, understanding the applicable regulatory requirement under the PIA and the NUPRC guidelines, and then gain practical, negotiation insights. Just to note that, when I got this topic, I sort of thought of, okay, so how do I do this? Should I drill down into, consortium arrangements? When you are bidding for an asset, or consortium agreements generally. But I think as I go through the presentation, I will introduce what consortium arrangements are, but I'm going to sort of be drilling down to using the usage of consortium agreements when we are bidding, or when participants are bidding for an asset, basically. So in recent times, the Nigerian upstream oil and gas sector has seen a significant increase, in the use of consortium arrangements or agreements, let me put it that way. So consortiums have always been there, right? People coming together to pool resources one way or the other to acquire one asset or the other. But given the recent regulatory framework in the passage of the PIA, the regulations after, and then the fact that, we've been having more and more, should I say, acreage allocations, bidding processes, and all, the use of, consortiums have now become very, 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 should I say, prolific or popular, because people have to sort of meet some financial or technical criteria that ideally they probably will not be able to meet on a standalone basis. So, but you have, such arrangements now being more, commonly used, in the upstream oil and gas sector. And so the next slide is just a brief introduction into what consortium arrangements are. So the NUPRC, current NUPRC guidelines for the 2025 bid round defines a consortium as a group of people, entities coming together to actually submit a bid to submit a bid for an asset. But beyond that, as I said earlier on, you don't find consortium arrangements in the sector only when people are bidding. There are times that people would come together to form a consortium just to acquire an asset, right? So in the recent divestment by IOCs, there have been people that have come together to form consortiums just to be able to just pool resources together to acquire the asset, right? So it's not just when you are acquiring or when you are bidding for new acreages or new assets that you see consortiums. But my presentation is just going to drill down on that because I would like to touch on some regulatory framework and draw our attention to certain things that we need to pay attention to when drafting and reviewing those kind of arrangements. But basically, a consortium is a group of people or group of entities and that will come together to either acquire an oil and gas asset or submit a bid, basically. And it's typically structured as an unincorporated joint venture, right? So the entities are not coming together at that moment to form a company or an incorporated venture. It's possible that eventually they would end up forming a company, maybe when the asset is awarded or the bid is successful or something. But at the consortium arrangement level, we're just individuals that are just coming together, to do this. And if our goal, maybe we are able to achieve the be successful at the bid or acquire the asset, then we could then go into more definitive, arrangements. And so the members retain their separate legal entities typically, and the obligations remain several at the level of the consortium arrangement or agreement and not joint. Again, governed by a consortium agreement that sets out a number of matters. Some of those things we will look into them as we go along, and then it's distinct from. Okay, so this point about it being distinct from a JOA, I noted this because I've seen instances where people try to negotiate certain terms that are best suited or that should be reserved for the definitive agreement stage, in the consortium at the consortium stage. So it's very important to just note that it's distinct from the from a JOA or from a or other definitive agreements such as your SHA, and all those other agreements that will govern that relationship when the asset has already been acquired. And when in the course of the presentation, I'll probably still speak to one or two instances or one or two errors that you see when people try to negotiate ahead, things that are meant to be negotiated later in the consortium agreement. Okay, next slide, please. Okay, so typical use cases, and I think I've sort of touched on this a little. You have indigenous companies, partnering with technical or financial partners. So, an indigenous company is partnering with maybe a foreign entity or even it could be another indigenous entity, to pull technical expertise from this, to pull financial opportunities from that. So basically, people coming together to sort of leverage on each other's strengths, as the case may be, to form a consortium for the purpose of achieving a goal. Companies lacking the individual capacity to meet the NEPRC minimum financial or technical criteria, coming together to pool resources to meet the criteria to place a bid or to acquire an asset, as the case may be. And then basically, forming of strategic alliances to reduce exploration risk and fund signature bonuses and other financial, costs that come with acquiring assets in the oil and gas sector. I mean, as we all know, the oil and gas sector is really capital intensive. And so a lot of times people have to pool resources together to be able to, to be able to acquire, to be able to have the leverage to acquire, whatever assets that they are looking to acquire. So these are sort of some typical use cases where you find consortium arrangements being used. Again, just to reiterate that even though my presentation would sort of drill down on, the usage of consortiums for the purpose of bidding for, assets, there are instances where people form consortiums, not necessarily for bidding for an asset, but maybe just to acquire an asset that is maybe being sold down, not necessarily by the regulator, maybe by an existing operator, an existing holder of a license. We just come together. Once the asset is acquired, they now go into more definitive, arrangements. Next slide, Digi. Okay. Again, I think this slide is just almost a rehash of what I've just said. The commercial rationale, pooling of resources to meet bid criteria, and sharing of financial commitments, access to blocks that otherwise you will not have had access to, as an individual. People entities combining technical capabilities for complex offshore operations, allocating operator responsibilities to the most qualified party, and then, of course, structured governance and decision making, especially at the bid phase, where a lot of decisions need to be made in terms of the assets to be acquired, what blocks are we looking at, what particular what particular leverage do we want to have, in the bid process, and of course, risk sharing, distribution of exploration risk across multiple parties, because at the exploration stage, there is no guarantee, right? But people are able to, when you are in a consortia, most of what the consortium agreement will deal with would be how we will share, those costs, those risks, of this arrangement, as the case may be. Yes, as somebody has asked that, can they get the slides after the webinar? Of course, that will be shared, I guess, with the organizers. Okay, please, can we just move to the next slide? Okay, so just a quick regulatory context, because my presentation, I want to just highlight a few, should I say, things or a few issues that have arisen, let me put it, issues that have arisen from, my recent reviews of certain agreements, and they were basically, consortium arrangements being entered into pursuant to, the ongoing bid process, right? So that's why I thought, okay, it'd be nice to just throw in the regulatory context. And why is this important? as lawyers, when we are drafting a consortium, it's easy for a consortium agreement to just be placed before me, and then I just review it for okay, what do I think favors my client? Oh, this clause favors this clause favors, without paying attention to the regulatory context. So I thought it was important to highlight the fact that the understanding of the regulatory context is important to drive your drafting and your review of consortium arrangements, when they come before you, if you ever have to, review one. So the PIA is there. That is, the PIA is obviously the ground norm, is the law that provides a framework for the bidding process, to be open, transparent, and competitive bidding process. There's a framework on the PIA. But pursuant to the PIA, there have now been regulations that have been issued by the regulators, the petroleum licensing round regulations, and then most importantly, the current NPR 2025 bid round guidelines, which provides for which recognizes the fact that an individual can bid for an asset, or a consortium, a group of people can come together to bid for an asset, and provide certain requirements that if you are reviewing a consortium agreement today for a party who is trying to acquire one of the assets that's currently being put to the bid process, you have to have an understanding of those regulations, of those guidelines, of those rules, to be able to do a proper review or drafting for your clients. So that's just the regulatory context that I thought to highlight on this page. Deji, please, next slide. Okay, so we quickly go into the drafting considerations, the key provisions, basically, that I'll quickly run through the scope and purpose clause. So just like an overview of what your typical consortium agreements would look like. You have the scope and purpose clause. You have exclusivity, non-complete, intellectual property, confidentiality, governance and decision making, cost and expense sharing, reps and warranties, indemnities, termination consequences, and dispute resolution. Of course, there are clauses such as your parties clause, definition and interpretation clause. I didn't mention that here, but of course, those clauses too are very, very important, because sometimes maybe we don't pay attention to, especially the definition clause, which can be very, very important in driving how your agreement, should I say, turns out. But I will just focus on I've just highlighted these basic provisions just to highlight certain things that we need to pay attention to when reviewing the consortium agreement. And also to say, a consortium agreement is like every other contract. It is a contract, as the case may be. So these are typical clauses that you will find in typical contracts. Only that being a consortium agreement, there are now certain things that you need to pay attention to. So I'll go into the next slide, which will so I go straight to the scope, purpose, and exclusivity. Your parties clause will have identified who the parties are, clearly the parties, the members of the consortium. Then you have a definition clause, and you have set out your private dictionary of what the terms that you have used, how they have been defined. Just to quickly say something around that definitions provision. So there are certain definitions, that you will see in the NEPRC guidelines, or certain meanings given to certain terms. Very important that if you are reviewing or drafting a consortium agreement, you want to align the terms with what the regulation or the guidelines are said. No point defining something in a different way when the regulations actually have defined it in one way. So it's just very important to pay attention to that. So for your scope and purpose clause, right, it should be clear that your that the purpose for entering into the consortium agreement, you are forming an unincorporated consortium, and I mentioned earlier on the members of the consortium up until an asset is awarded, and until they decide or they are successful enough to go to the next stage of then now entering into more definitive arrangements. They are individually they are individuals, that individual legal entities, and their obligations are several, not joint. So the specific purpose for which you are entering into the consortium has to be clearly stated in the agreement, which is you are preparing this, you are entering this consortium for the purpose of preparing and submitting a bid or direct action of an asset, the specific assets that you want to acquire also needs to be stated in that agreement. And if there is no, I mean, I've seen an agreement where the parties were not even sure which specific assets they were going to acquire, but they had an interesting concept called area of mutual interest. So these are the areas that we are looking at. And so, but as the bid process goes along, we'll be making the decision as to which particular asset to bid for. Now, your consortium agreement is very important because it is a requirement of the of the guidelines that if you are bidding through a consortium, if the consortium is bidding, you have to submit the consortium agreement to the regulator, and these certain things have to be in the consortium agreement that that the regulator would like to see. So the specific assets we bidded for or acquired, then it should be clearly stated that you are not forming a partnership at that level. You are separate legal entities for now. So this is just for the purpose of us coming together to bid for this asset or to acquire this asset as the case may be. Then the exclusivity and non-compete was also another clause that I thought very important to highlight. Now, you can imagine parties coming together to acquire an asset, but then in the same should I say group or in the same consortium, then you now have one or two people who are bidding for the same asset with another consortium or even another asset, with another party. So basically, your exclusive and non-compete clause is very critical, very important, so that it's clear that you are the parties are not undermining the efforts of one another by being in a particular consortium. So you are in the consortium, you cannot bid for the same block independently, right? And you cannot join another consortium, for the same block. And even the regulations actually provide that once you are in one consortium for a particular set, you can then now not be in another consortium for the same asset. So very, very important for your exclusivity and non-compete clause to be clear as to the impossibility of parties to then bid for the blocks or other blocks with other parties. Now, I've seen a consortium agreement where the parties were maybe they were trying to be nice or I don't know to one another, and then there was a provision that seemed to suggest that a party can actually try to bid for the same asset with another consortium, only that you would get the consent of the other. You just struck it out that you cannot be trying to provide consent for what the law or the regulations have expressly prohibited. So that's another reason why the understanding of what the regulations say or the guidelines say very important in driving how we draft and review these agreements. So I'll go straight to the next slide. Yes, and okay, so then this is another very, very important part of the agreement, which is the governance and the decision making. A typical consultant agreement will have sort of a steering committee or management committee, which will be established within a timeline after the execution of the agreement. Now, the essence of this committee, basically, because as you can imagine, the consortium, you can have more than one party, but that's why it's a consortium, right? So you can have 2, 3, 4, 5, people coming together, entities coming together to acquire or to bid. So the whole idea of a steering committee or management committee is to have a body of persons who would be responsible for making decisions on behalf, of the consortium for the purpose of the bid. Now, the guidelines even go ahead to, provide for something like that, and I think it's number 5 here, something called an authorized representative. And the authorized representative must be from the lead member with a power of attorney. Now, and I'll go back to who a lead member is. So, but the most important thing about the authorized representative is that this is the person who would have the, should I say, the power or the right or the obligation to engage with the regulator throughout the bid process on behalf of the consortium. Any person cannot be talking to every member of the consortium, everyone. However, the decisions of that or the engagement of that authorized representative on behalf of the consortium is driven by decisions made by the steering committee or the management committee, as the case may be, whatever the name is called in the agreement. But the most important thing is that the framework for representation on that committee, quorum provisions for decision making, right? Just like your typical SHA, whether you have a chairman with or without a casting vote, your decision making thresholds, what decisions will require unanimity of all the parties, what matters will require just a majority consent, deadlock resolution mechanisms. All these have to be clearly and expressly set out in the document so that you are not the consortium or the consortium is not bogged down by inability, to make decisions. I talked about lead party. Now, the regulations or the guidelines provide that the lead party will be the operator, at least as a post award operator. You can have a post award operator, but the pre award operator, as case may be, and the lead party must have at least 30%, right? So the any attempt to make somebody else who has maybe less than 30% the lead, would immediately be, let's say, struck down by the NPRC, because the guidelines require that lead member has to have at least 30% of the interest or the participating interest that they're hoping to acquire. Of course, you can have more than 30, but at least the minimum, is 30%. And the authorized representative of that consortium must be a member from that lead, it must be from that lead member. Must be from the lead member and will be the one that has the right and authority to negotiate or discuss with the NUPRC. Now, this is important because why? In drafting your consortium agreement and reviewing, it's important that the members are clear, as to who the authorized representative is and the powers of the authorized representative, how decisions will be made and all, just so that you have a smooth process, and then that your consortium agreement is even one that will not be jettisoned by the NUPRC once you submit it for the bid process. I think I'll quickly move to the next slide, Deji. Yeah, cost and expense sharing, another very important provision in your consortium agreement. So the key principles around the internal costs, so personnel overheads, will be borne, personnel, for example, all the people that are, the traveling expenses on behalf of the consortium, engaging contractors to do data acquisition and all those on behalf, all those costs, right, have that you will spend in the internal. We call them internal costs because it's amongst you. You have to spend those costs, right? You will determine how the cost will be shared. Usually, it is pro rata in accordance with the interest of each party. Then external costs as well. You determine how those will be shared as well. Sorry, I think I just made a slight let me just take that back. So internal costs are costs that are internal to you as a consortium member, right? So you bear that individually. External, so things like the regulatory, and you are engaging a lawyer to on behalf of the consortium. You are paying consultant fees. All those costs you will determine how they'll be shared. Then of course, cost overrun approval mechanisms have to be clearly stated for the committee to be the party or to be the body to approve cost overruns when you have maybe exceeded your budget on certain matters. And then regulatory fees, very, very critical. Regulatory fees to be shared according to agreed proportions. Signature bonus, for example, if you are successful, the signature bonus can range from 3 million USD to up to 10 million USD, depending on where the block for deep offshore blocks. So that again will be set out in the agreement how parties will be shared. Again, most of these costs are shared pro rata. Once it has to do with external, regulatory or external costs, it's typically shared pro rata according to the interest of the parties. So it's important that your the consortium agreement that you are drafting or reviewing is clear and explicit as to how these costs will be shared amongst the consortium members. Next slide, please. So representation and warranties and indemnities, another key provision of your consortium agreement. And just like any contract, your reps and warranties are in fact that induce the other party to enter into a contract with you. So your standard representations that you see will include, you are duly incorporated and you are validly existing, you comply with laws, authority and capacity to enter into agreements, no insolvency, conflicts with existing obligations, and all the typical representations that you give. And why do you have those representations? In the event that any representation is false or misleading, that can be a ground for the other consortium members to have a claim against the member. So it's very important when you are drafting for a consortium member, because most times you probably be on one side, right, of the consortium. Very important to ensure that your client reads the representations and is clear that they can give those representations. So that any representation that they cannot give, and it's either you are taking it out or you are having some sort of disclosures against it, so that it doesn't lead to a breach, in future. And then indemnity is typically another clause that parties will heavily negotiate. So triggers will be willful misconduct, negligence, breach of bid guidelines by a member of the consortium, or maybe the lead member, or or any other member of the consortium. And so the whole idea of indemnity provision is to have provisions that will ensure that the party that is in the wrongful party indemnifies the other members of the consortium for any wrong or any loss that will be suffered, as a result of the conduct, of the breaching party, as the case may be. So you have some exclusions or some key protections that you typically have in that provision. And one of them, which I call the consequential loss exclusion, basically is just to make it clear that, because as you can imagine, the party who is sort of the authorized representative or the lead member will sort of have a lot of responsibility, right? And so the whole idea is, if a party is indemnifying another party, it has to be clear what I'm indemnifying you for. But I cannot indemnify you for maybe certain things that are not necessarily flowing directly from my willful misconduct or negligence or breach. I.e., if you have suffered some loss that is not directly linked to, this bid process, or, this bid process, as the case may be, then I cannot be held responsible. So you have proper carve-outs for things that I cannot be responsible for. So say things that I will not indemnify you for, or you will not indemnify me for. Then you have your claims procedure expressly set out in the document. You have your consent requirement prior to settlement of claims, and of course indemnity on withdrawal or breach. So if a party is withdrawing, or has breached, then you indemnify the other parties. So this will range. I mean, indemnity is indemnity, right? But the kind of carve out, the kind of exclusions that you have probably depend on the commercial intentions of the parties that you are representing or that are in the particular consortium. But the most important thing is to be clear what your clients or what the party you're acting for wants, and how to ensure that their interest is adequately protected and they are able to be indemnified in the event of the happening of any one of the things that have been stated in the agreement. Next slide. Okay. Then term and termination. So term and dispute resolution, termination and dispute resolution. Another clause in your consortium agreement. The term typically say the agreement is in force from when you sign it until it's terminated, or maybe when it's superseded by the definitive agreement and you enter into post award, or basically just parties terminating the agreement willfully. Maybe if for whatever reason they don't even just want to continue with the bid anymore, but the agreement will actually set out the termination event, which is what I have on the next slide, which is basically there could be voluntary withdrawal with notice, like okay, we're not doing again. We don't think, based on maybe what we've seen, we've engaged, a consultant to, retrieve data from the assets that we are looking to acquire. We don't think that this will be worth our while. We want to voluntarily withdraw and terminate, that could be a termination trigger. Material breaches. If there's a breach by one party or the other, the non-breaching party may decide to terminate the agreement. That is also another termination trigger that you find depending on the number of parties, nature of parties in the consortium. Automatic termination provisions could also be in your provision. So, for example, if the bid is rejected or the asset is awarded to other people, then obviously there is no need for the consortium anymore. And of course, execution of your definitive agreement upon a successful award. Definitive agreement will probably include your JOA, your SHA, as the case may be, because now NEPRC requires you to incorporate an SPV upon the successful bid process that will be the operator. So that SPV, you would have to have an SHA and all those agreements. So obviously, when you have those definitive agreements, your consortium agreement will fall away. And of course, in the event of a force majeure by termination code, the agreement could provide for if force majeure is affecting a particular party and is not remedied within a particular number of days, then the agreement can be terminated by the unaffected party. And of course, consequences of termination has to be expressly stated again in your agreement. Accrued rights have to be preserved. If we've spent money, if the authorized representative has maybe spent some money or made some expenses on behalf of the consortium based on what was agreed at the committee level, there'll have to be reimbursement of the authorized representative in the event that the should I say expense was made by the authorized representative. Those kind of accrued rights are preserved. There will be surviving clauses, your confidentiality clause, typically IP in the event that we share some intellectual property amongst ourselves as consortium members, and of course your dispute resolution in the event that I have to go after you for something. Those clauses are typically surviving clauses. And then, of course, the withdrawing party will typically, bear the cost of your own withdrawal. But if a consortium is made up of two parties and one party is withdrawing, it's either the other party continues, and I can believe that you probably need the NUPRC's consent to then continue as an individual, or if the individual party can then not continue on its own, then obviously that arrangement has to come to an end, with proper indemnities. Then you have your governing law your governing law, clause, which typically should be Nigerian law, but I mentioned earlier on that you could have a consortium arrangement where you are not even necessarily acquiring you are not bidding for an asset, but you are probably just acquiring an asset. You want to pool resources to acquire an asset that is being sold down, say for example, by an IOC, and you are coming together as a consortium to say we'll pool resources and then we'll form an SPV that will be the should I say buyer of the asset. It's not impossible for parties, depending on who they are or what their commercial, should I say, intentions are, to have, English law or another foreign law govern that consortium agreement amongst them. But I think, it's always preferable when, in your typical, you are bidding for a Nigerian asset, your Nigerian entities, even if the one or two members of the consortium are not Nigerian entities, it's always preferable to just sit with Nigerian law. Everything is happening in Nigeria. So Nigerian law being your governing law. Your dispute resolution clause should be Nigerian arbitration, and not LCIA, all those London arbitration, which can be very expensive for the parties. This is just a consortium agreement, for crying out loud. We don't even know if the venture is going to be successful. So anything that would make us then spend or drag a process in a foreign country when we need not do that, might as well be, should I say, minimized or eliminated from day one. So we always prefer, or I always prefer, Nigerian law as much as possible for your consortium agreement, and then of course Nigerian dispute resolution. And then you have your dispute resolution, which is typically an arbitration. But before you go to arbitration, you'll have been provided, there will be opportunity for parties to either discuss, settle, mediate, or do one or two things before you know that, okay, then we totally cannot resolve this. We need to go to arbitration. And, arbitration again should be just Nigerian arbitration as much as possible. But then again, it's not impossible to have, foreign law or foreign dispute resolution. But the most important thing I think in this part is to ensure that your agreement is clear on the governing law and the dispute resolution forum. Very important. Okay. Next slide, Dij. Okay. So I'll move quickly. Drafting consideration. So I mentioned earlier on that I've seen and these considerations that I've highlighted, they are just few things that I've seen from my own personal experience. For example, the last consortium agreement that I reviewed, when the agreement came, we were wondering that, sorry, is this a consortium agreement or is this a JOA? Do you have this asset yet? They had provisions that you typically see in a JOA, sole risk provisions, all sorts. Like, it was as good as, this is our JOA, right? And we thought, okay, at the consortium level, you really don't need to bog yourself down so much with things that should come at the definitive agreement stage. So it's better to leave your consortium agreement simple, straight to the point, scope and purpose. We're just coming together to pool these resources to acquire for the purpose of this bid, and this is XYZ that we'll do for the purpose of the bid. After a successful bid, then we'll go into our definitive agreement or arrangement. So keep the consortium agreement focused on the bid phase and defer your JOA terms or whatever terms, your SHA terms, also to your definitive agreement. You've seen consortium arrangements sometimes that even seem to look like SHA. Just keep it as simple as possible and straight to the point. Including consent mechanism, and I think I spoke to that earlier on, where I said in an agreement that we reviewed that we're trying to introduce a consent mechanism for something that is that's been prohibited by the regulation. So that's why the understanding of the regulatory framework is very important in drafting. So there's no need to be putting consent when it's not possible, right? So the law is clear. So those are the kind of things, just take out and say, see, the law does not allow this, the regulation does not allow this. So just align your documentation with the regulations. Applying English law, LCI arbitration without considering cost implications. The last one we successfully took out all the parties were Nigerian entities, local entities, indigenous companies trying to bid. There was absolutely no need for us to go to England if there's a dispute or the LCI. So please, let's keep it local, right? We're acquiring a local asset. So that we're able to get through. And then of course because they were looking, the document had foreign English law and then English arbitration and all, had some foreign law, English law clauses that typically you don't need to have it in a document that is governed by Nigerian law. So those again are just making your agreement unnecessarily long and winding. What the NUPRC wants to see in your consortium agreement does not include all these kind of things. And then failing to include adequate governance provisions for your committee. I talked about how important your governance committee, the committees are for the purpose of making decisions, engaging the regulator, because the decision at committee level will drive what the authorized representative or anybody that is engaging the regulator on behalf of the consortium will do. So very important to have adequate governance provisions, and of course misaligning provisions of the document. I think is a type where misaligning provisions within misaligning provisions of the consortium agreements with the guidelines. So your consortium agreement, the provisions have to be aligned with what the guidelines have provided for. Definitions should be consistent. Concepts, that we should really be consistent. Because at the end of the day, this is about acquiring an asset that the NUPRC is putting out. So the guidelines should drive as much as possible, the drafting and the review of such agreements. Next slide. Okay. So a few negotiation considerations that I thought we should also highlight. So, there is a lead member and there is a minority, and that the minority members, right? And I mentioned again that, I mentioned earlier on that the lead member must have at least 30%. So, in your consortium arrangement, whoever is the lead member must have at least 30%. But so I can imagine if you are acting on behalf of the lead member or the minority member, there are certain things that I just think that we should be taking into consideration, and I've highlighted a few here, right? Depending on which side you are. So from a lead member's perspective, you probably want to have and all these are negotiation strategies, right? And there's nothing cast in stone, but are just things that we should think about when we are advising, and depending on which side you are on. So you want to think about securing your casting vote or weighted voting, reflecting your larger participating interest, right? You want to have some authority to bind the consortium vis-a-vis the NUPRC without requiring counterparty sign-off on all communications. Don't forget that I said the authorized representative comes from the lead member. Most of the engagement with the NUPRC comes from the lead member, but you want to also ensure that there could be certain times that decisions need to be made that are not necessarily, should I say, critical or or that are not sort of substantial. Let me put it that way. So you want to ensure that there are certain rights that you have. So maybe not all decision making should be unanimous, right? You want to have certain decisions that should just be a majority decision, and so that we can continue this engagement without any hassles, as the case may be. You want to protect yourself against non-operator defaults, forfeiture of provisions and default interest provisions. You want to limit your indemnity exposure as well. And I've already spoken to that consequential loss exclusion with narrow carve out, because you're probably the one that's engaging the most with the regulator. So you're probably the one that is having maybe exposed to claims of negligence, willful misconduct, and breach, right? So you want to have provisions that will adequately protect yourself. You want to have the right to appoint development operator post award. That if post the award, you want to be able to have a right to ensure that whoever is operating has the the technical expertise, then put it that way, to do the operations, assuming you are not the one already. Cost overrun controls, you want to ensure that is also in the document from a lead member's perspective. You want clear termination rights if the counterparty fails to fund or breaches, right? Because as you can imagine, most of the contributions I said earlier on will be majorly based on the participating interest or on the proposed participating interest. So as a lead member, you're probably the one that is taking, you're carrying most of the cost. And so in the event that there's something that needs to be done, and then the counterparties are not or the counterparty is not pulling their weight quickly or whatever, you want to have clear termination rights, right? So that you are not bogged down with a party that will not make you achieve your aim or your commercial goal. You want to be able to retain the ability to bring in additional equity or debt provider, post award. Then from the minority members' perspective, you want adequate representation on the steering and management committee regardless of interest or size. So it's possible for you to be able to negotiate equal representation, for example. Nothing stops, but the fact that you are 60 and I'm 40 does not mean we cannot have equal representation, right? Then you want to ensure that most of the material decisions, are subject to unanimous consent. You can't change the bid terms. You can't just overrun a budget just like that. we have to unanimously agree. Anti-dilution protection like preemption rights if the lead member is seeking to bring in new partners at the consortium level. Information rights, you want to have full access to bid documentation. You want to ensure that your non-compete survives termination for a reasonable period. You want to ensure that the insurance requirement, ensure that your person maintains some adequate coverage at that level that you are bidding. Right to participate in definitive agreement negotiations post award. Like I said, you'll be having you'll be what's that word? Post award is when you are going to have your definitive agreement, right? So the award is, if the bid is successful, then there will be agreement entered to post award, and you want to have a right to participate obviously in those in the negotiations of those agreements. And then of course in the event that the lead member seeks to just transfer, or if you want to have some tag along rights, ability to also be able to get out of the consortium in the event that lead member seeks to go. So these are just a few, negotiation considerations. And then just know that not every consortium agreement are this detailed, right? Some consortium agreement don't even have as much details as this, but some, for some reason, just have, very, very detailed, governance provisions on lead member, management member perspective. So in the event that such agreements, you are reviewing it especially, you want to know what to watch out for, whether you're representing the lead member or the minority member. And I just thought to highlight some of these things that I've seen, reviewing some of these agreements. Next page, next slide. Okay, so some key takeaways, and I think so. One is you tailor your consortium agreement to the specific bid phase, avoiding and avoid importing premature definitive agreement terms. Ensure, and most of these things obviously I've already spoken to them in the course of the discussion. So you want to ensure alignment with terms in your in the guidelines and regulations. You want to ensure robust governance, quorum voting, deadlock mechanism provisions in your document to the extent that those are critical, especially when you're acting from a lead member perspective. And you can imagine there was some argument I reviewed that there were just two parties, and one party was 80%. So clearly the lead member, right? Address cost sharing comprehensively, your internal versus external costs, your overruns, all those costs, how they will be timing for payment, and all those things that can actually hamper the smooth run of the bid process. You want to ensure that those are adequately provided for in the document. You want to choose Nigerian law. Well, I've already explained that as much as possible, and just think through why you want to go abroad in the event of any difficulty. If there's no need, there's really no need. You want to keep it as simple as possible. This is just a consortium agreement. You want to include clear termination triggers with appropriate cure periods to ensure that in the event that this bid is not successful, or if a party is withdrawing, or if a party is breaching, you have to ensure that how your agreement will come to an end is also very clear, in the document. And then, of course, planning for your post-award transition. I mean, like I said, the agreement shouldn't then have too many provisions. And I think that's probably what happened in the one of those agreements that I mentioned earlier on that I reviewed. Having JOA, it was like as if we were reading a JOA, which was not necessary, but I guess it was, we just want to sort of have an idea of what our life will be like post-award. We are still at the bid phase. No need to have elaborate provisions, but it should be clear though. Some provisions in the agreement that will just say that you are going to be entering into those definitive agreements, at the appropriate time. And you can even decide amongst yourself to have, a term sheet or term sheets for some of those agreements already. But like I said, those are not necessary for the purpose of the consortium agreement, as case may be. That's not what any parent wants to see. But I mean, it's one of the things that one can suggest, that you can have your head of terms, all those things for those agreements, but keep your consortium agreement, simple, straight, and straight to the point. And of course, I had to put this one: engage experienced legal counsel early. Don't wait till the don't wait till too late. Okay, I'm talking to lawyers, so this is what we should be telling people, that engage us right on time so that we can help you to review your agreement on time, and direct you appropriately, so that you don't make mistakes that are irreparable. So I think those so that's the last point on this slide. And and I go straight to the Q&A. Thank you everyone for your time. Just hope that I've been able to pass some points across. Thank you.
All right.
Okay.
Thank you. Thank you,
Thank you so much.
Folashade.
Thank you, Adetola. And once
Yes.
again, Adetola, apologies. I really, really apologize for this on inability to show my face. I just
It's
had
all
no
right.
idea that was going to happen. Apologies to everyone.
It's all right.
Nice.
Okay. Yes. Thank you, everyone. My name is Aditola Jimo, the moderator for this. But due to technical issues, we've had a lot going on. But thank you for staying with us. Thank you for your patience. We really appreciate your presence here at our webinar. And the floor is open for questions. You can type in your questions in the chat box. I know we've learned so much. So ask your questions, please.
Yes, please. Thank you. And just to add, Aditola and everyone, that my picture is on our website. So for those who have not seen me before, just achieve that thing.
Yes, exactly. A picture is there, so she's a real person.
Yeah, exactly.
Okay, some Confidence wants to know what the difference is between a JOA and a JVA.
Okay, I want to just to be clear, the JOA is a joint operating agreement. I can imagine, right? And then the JVA is a joint venture agreement. Just to be clear, can the person just signify that I got that right? JOA, I know is joint operating agreement, but JVA, I want to assume that is a joint venture agreement, right?
Right.
Okay.
I think that's correct.
Yeah. And I think Confidence has said so. Yeah. So, your JOA, that joint operating agreement is an agreement that is, and I want to say this right, that's the basic agreement or arrangement amongst parties who are who jointly hold an oil and gas asset and are jointly operating. Let me just put it that way. So as the name is, your joint operating agreement. And a joint operating agreement, to my mind, is like an example of a joint venture agreement, right? But it's just that your JOA is that agreement that sets out how the parties' rights and obligations in respect of the assets that they are jointly holding. And so you would have your the JOA setting out your participating interest in the cash call obligations, so risk of operations, assignment, provision, termination, and all whatnot in relation to the operation of the assets. You set out who the operator is, the rights of the operator, everything in relation to the assets that parties are jointly holding. To my mind, the joint venture agreement, I think, what's a joint venture? Two parties coming together to do a venture. So a joint venture agreement can range from anything. It can be it could be an agreement in another sector that is not necessarily oil and gas. It's just a joint venture, parties coming together to jointly carry out a venture. And I would say that I think a JOA is a type of a JVA, but the JOA is an agreement, or is a terminology. Yes, an agreement that is used in the oil and gas upstream for parties who are jointly operating an asset, to set out the operator, everything that has to do with the operation of the asset. And I hope that helps, but I think that's the best way, and I can explain it. JOA is a special term, is a term that every JOA, you know what a JOA is in the upstream oil and gas sector. But a JVA can be any agreement, a joint venture agreement, and can relate to anything that parties want together. It does not necessarily have to be in relation to an upstream asset. could be a midstream asset, it could be anything. But as the name suggests, it's just a joint venture amongst us, and we're coming together to agree how we want to, jointly carry out this venture. That's, I think, the way I can. I hope that helps. Comfort. I think it was comfort.
Confidence.
Confidence.
Yeah. Yes. Okay. Fumi asked, how does the agreement handle joint and several liability among consortium members if a major supply chain disruption or trade embargo occurs?
Okay, that's a beautiful question. But I think I mentioned earlier on that, the obligation, at least based on my own little experience, if I'm permitted to say, at the consortium level, the obligations are typically several and not joint. Several in the sense that each one of us will bear the liability or the cost in accordance with our participating interest, as the case may be. So if the supply chain, or I can't remember the way she phrased the question, but if there is an issue, right, each and every one of us have, you are severally liable. So if there is a payment to be made or a cost to be incurred, each one of us have to bear it. I'm not going to be liable for your own misconduct. You are not going to be liable for your own misconduct, and that's where the indemnities come in. So if there's no cost to be paid or anything, you would, and applying the principle of what I had spoken to earlier on, we would jointly we would bear the cost according to our proportion. But however, if as a result of your willful misconduct or your negligence or your breach that we are having to incur this cost or incur this expense, then you will indemnify me for the cost that I have to pay, because our liabilities are several at that stage. We are not yet in the assets. We are not yet together. And don't forget, I mentioned it's not a partnership, it's not an incorporated venture, it's unincorporated. We are separate entities, and we're just trying to see how we can agree, how we can come together to achieve a common purpose. So I think, I don't know if that helps. There's a follow-up on that.
I think that's clear. Also, she has a number of questions. So
okay.
Yeah. Okay. So she said, another question: in large-scale energy infrastructure projects, how can consortium members best negotiate limitation of liability clauses with the host government or primary contractor?
Okay. So, host government, yeah, primary contractor, and I'll just take them separately. Okay. Now, your host, so just to take us back, we are looking at this topic is drafting a review of consortium agreements. And the consortium agreement that I've tried to, should I say, discuss on this at this meeting is, that arrangement that you have pre-award. So pre-award, you don't have the asset yet. So you probably may not be having host community issues per se. I know that, of course, prior to your the award and all that, probably want to gather data, seismic and all those things. I'm not sure that those processes, and of course, I stand to be corrected, I'm not sure those processes throw up so much of host communities or host government issues as the case may be, right? So when you're talking about dealing with host government and all those things, you are probably already looking at a situation whereby we are now in the asset, and you can correct me if I'm wrong. So you're already in the JOA, you already have an asset. You're now having to deal with host communities, or you're dealing with host government. You are dealing with several issues that have to now do with your exploration activities, your production activities, as the case may be, right? And maybe she can clarify if that's the case. And when you talk about primary contractors and all that, prior to your award at the bid stage, you are engaging one or two contractors maybe to gather data to do that. How do you deal with your with your liabilities amongst yourselves? Again, your document, and that's why I was speaking to being explicit about how you will share costs and expenses. And cost and expenses at the consortium level, please, at the consortium level. At the consortium level, most of the contractors or people that you're dealing with are just people that are helping to gather data and helping to do the seismic test and all those things, because you don't yet have the assets, right? It's post award that you then now have the asset that you now be dealing with, how do we move to site, how do we move to the block, how do we, all those things. So I don't know if she can clarify if I'm right in sort of separating, so that I can then maybe try to answer in the context of you already have the assets. But I just wanted to be clear that she got the distinction, he or she got the distinction that at this consortium level that we're discussing, you are not yet in the assets. This is just we are trying to arrange ourselves, we are trying to come together to acquire something in the future.
Okay. So next question: what provisions are essential for allocating the risk of regulatory changes or sudden tariffs among consortium partners?
Please, can you say that again?
All right. What provisions are essential for allocating the risk of regulatory changes or sudden tariffs among consortium partners?
So the risk of
Regulatory changes, yes, regulatory changes or sudden tariffs.
Okay, sudden tariffs. Okay, so provisions are to be essential. Okay, so thinking about it, because again, the consortium members, just to note that at the consortium stage, you don't have there is no asset. So you are just trying to come together to bid. So I can imagine that your agreements could have force majeure provisions that can deal with unintended things that are beyond the control of both parties. And because your liabilities or your risk as at that level is several, not joint. If something happens that was beyond the control of the parties, the agreement already have a termination provision. The force majeure has occurred, we terminate. If there are sudden tariffs, again, the sudden tariffs is not because you don't want to continue, but it's just because maybe the cost has gone higher. Again, you are individual members, each of you bear your cost. And I talked about the costs. I talked about a provision that has to do with cost sharing and all those things. And I also talked about, when I was talking about if as a lead member, you need to make some payments, or you need to pay for certain regulatory, and then the other party is not providing, you are going to provide for what to do at that time, and how you are going to be reimbursed or indemnified for any cost. So I would just say, the kind of provisions that you will see, will just basically be, for regulatory changes, or sudden tariff changes, or anything that's probably outside the control of your parties. Some things will lead to termination, something will lead to termination, and some things are just not talking about how I'll be reimbursed or indemnified. I talk about the indemnity provisions for if one party has to bear a cost on your behalf. Fine, it was not in the budget, right? But unfortunately, it has gone up. We both did not expect it. I've done it, but you indemnify me. So I don't know if those are part of the provisions, some of the provisions that you can think in tamper with to assist in allocating such risk, basically. Yeah.
All right, thank you very much. So our last question was how does the agreement distinguish between pre-existing IP and new IP generated during the collaborative project?
Pre-existing IP, i.e., the IP of one party, and then yes, and then IP generated. So that's a very, very interesting question, because part of the provisions that your consortium agreement, and I think I mentioned it, but maybe I just didn't drill down in it. You have the provisions on IP, who owns what, who owns that. So your IP provision, right, can actually state that IP, my IP is my IP because I brought this. But any IP that's now then jointly, maybe for some information, for some intelligent information that will be jointly, create or gathered in the course of the bid, it will be collectively our IP. But don't forget again that you are still individual entities up until you get the asset, right? So at that point, the IP is at the end of the day, what's the essence of the IP when you don't even have the assets, right? So the most important thing is, your IP remains your IP. My IP remains my IP. Any IP that we then now jointly say we have, I guess, is something that at the end of when you have your assets, or if the bid is successful, some of your definitive agreements can then now deal with, for example, you are incorporating an entity together to hold that IP. What will happen if your bid is not successful? To be honest, I'm not even sure I have a right answer to that now. But I think a very good way of dealing with such, IP, right, that is jointly owned by both parties at the consortium stage is just to transfer it to the entity that we're going to jointly then incorporate to all the assets, or as the case may be, post award if successful. I don't know if that helps the person that asked that question. That person must really be an IP person. But I
Yeah.
think that's the best I can offer on that.
Okay. All right. Follow up to the JOA and
Okay.
JVA. We have two follow-up questions. So, Sophia asks, so a
Adesola, please, you are breaking up.
JOA can be part of a JVA and need not be separate.
Yeah, I can hear you better now. Yes.
Can you hear me? Okay. So she asked if a JOA can be part of a JVA and does not need to be separate.
That's an interesting question. Why is your GOA part of your JVA? Maybe he or she is dealing with something now, because your JOA, so your JOA, let me just put it this way. Your JOA, your joint operating agreement, as we call it in the sector, is really an agreement that is showing that both of us are in this venture together. I don't know if that makes any sense. So if it's an appellation issue, when you say can your JOA be your JVA, maybe you have a JVA that has all the provisions that a JOA would typically have. At the end of the day, it's just an appellation point, right? But when anybody says JOA in the upstream sector, we all know what we're talking about, right? It's that agreement that really set out the rights of the party in relation to the asset that they're holding. It will show what's your participating interest, what's my participating interest. Everything has to do with the asset, the operator of that, and all those things. But your JVA does not necessarily, may not be a JOA. That's my point. It may not be a JOA as we know it. It could be a joint venture between both of us to acquire a rig and then establish an SPV to hold the rig. That's a joint venture. I don't know if that makes any sense. So if this JOA is inside the JVA, well, all well and good. Maybe I don't know. I wish you could really tell, maybe say what the concern really is, but I don't think there's a problem if your JOA is in your JVA. But what we know the agreement is called is a JOA. That's it. Yeah, I would say a JVA. It's a JOA,
Okay.
joint operating agreement, especially because of what the agreement seeks to do. You are operating an asset. That's what you are doing when you hold participating interest in an asset. You're operating it. So the right appellation is the JOA. So, but again, I think it's a type of a joint venture agreement.
Okay.
So,
all right. Confidence.
I hope I'm not
I think that's
Confidence can reach out to me if she wants us to discuss
okay.
further. Yeah.
Okay. And then I think that was Safia. Yeah, now this is Confidence's follow-up to the JOA question. And then Confidence asked, after the asset is awarded, then the consortium becomes incorporated joint venture, right?
They would typically, so your consortium, after the asset is awarded, then you now have, maybe you form an SPV that will hold the asset. And with these NUPRC guidelines, we even require the parties to actually incorporate a company that would be the operator of the asset, and would then all the members of the consortium will then be like shareholders in that in that SPV, right? But I can imagine even if there was no such, how will I put it? If there was no such requirement to incorporate an SPV, right? The way a JOA works, right? We don't even have to be in a company to be operating partners. I don't know if that makes any sense. So post award, what do we just do? We just then enter into our joint operating agreement straight on. But the rules now so require you form an SPV, then you now enter, that SPV becomes the operator of the assets. Then you then have, all the consortium members being, shareholders in that SPV, and all that. And then you still have your JOA, then you have your SHA, the shareholders agreement, all these things sort of throw, interesting and new dynamics into the mix. Because I've been part of a process before where, we're reviewing the SHA. These were parties that were members of the consortium. They got awarded an asset. This was from the 2024 bid rounds. They got awarded an asset. Then, of course, we now got to the stage of negotiating the SHA and the JOA. And there was now an issue as to whether you should be putting asset-related matters into the shareholders agreement, which was really supposed to be dealing with governance at the corporate level. So those are, interesting dynamics, right? But just to say to the person that post-award, you then incorporate, then you then have your JOA and all those agreements. But if there was no such, requirement to incorporate the company, just simply go into your JOA and then you have an unincorporated JOA, an unincorporated JOA, which is how most JOAs are anyway. Parties are unincorporated. They are just individual entities that hold participating interest. They are not in the UJV. But I don't want to go into all the story around, by the PIA now, you can now have parties now coming together to form a UJV, parties that were initially JOA, unincorporated, now coming together to form an incorporated entity and all that. But that's no story for another day. But yeah, I hope I've answered that question.
I hope so too. If they are not clear, they can reach out to you.
Please, very, very, I'm very open to receiving questions or engagements.
Okay. One more question before asking for a template of a consortium agreement. Tassemobi asked, this is a mouthful, so I'll read it carefully. What happens where parties execute a consortium agreement, acquire the asset, but are unable to agree on the definitive terms after the asset is acquired? Will a safer strategy be to execute a consortium agreement along with a definitive agreement at the same time? In that way, all parties are agreed before they proceed with acquisitions of the assets.
Do you know why I love that question? I love that question because whoever asked that question just described a nightmare that that I sort of encountered a couple of years ago. That's exactly what happened. The parties acquired the assets, or they won the bid, but they were just unable to agree definitive terms. It was impossible, and the reason why was mainly because it wasn't the JOA that was the problem. It was more of the shareholders agreement. I mentioned that they have this rule now that you have to incorporate an SPV, then the SPV becomes the operator, blah blah blah. It's operator that doesn't have technical expertise, So it was a nightmare because for some reasons the parties were not able to agree. So yes, you may then think that, if that's the case, why don't we, at the consortium level agree that? But guess what? Whether you try to, at the pre-bid level, agree that, whether you try to agree ahead or you agree post, if parties are unable to work together, they're unable to work together. So in that transaction that I'm talking about, eventually one of the parties left or something, they got another party to, and it was a bit messy. Another party to acquire the interest, of course, required ministerial consent because you already have an interest in an asset, and to assign it, you need ministerial consent, to assign to another party. Eventually, they had to sort of go separately. Some members left, but the point is, I can imagine if they had tried to do that at the pre-bid level, they would never have gotten the bid in the first place. I don't know if that makes any sense. So, these things is really, it's when we are in practice that when we see this thing happening like that, maybe makes sense. If you now say, let's bog down the process of doing this bid because you are trying to agree definitive agreement, I don't know how that will impact on timelines, right? So what she has asked is possible, right? But the question about whether it is then now the best way to go, I guess it would depend on the consortium members, their commercial intention, how easy they are to give up on issues, and how I don't know how easy it is for them to sort of agree things and work together. I don't know. But honestly, I can imagine if this was going to happen in that transaction I said I applied on, they would never have gotten the bid in the first place because even the the consortium agreement just dealt with, okay, let's just go and bid. They got the bid, then they were now unable to proceed because they were just not able to agree things. So imagine if that was happening pre-bid. So what will happen? They will never have been able to submit the consortium agreement because they will just not be adding them and they will never even get the bid. So why not just wait till after and bog yourself down with issues that have to do with operations and all that at that time, and then do what you have to do at least to get a leg in because you need that consortium agreement to submit your bid, right? So I don't know if that helps, but at the end of the day, it is really what the parties want. Anything is possible. You can do that, but whether that will be expedient for the purpose of your transaction and what we'll be advising a client to do will depend on the facts and circumstances of each case.
Okay.
I don't know if
I think that's clear. Thank you very much. So majority of the attendees are asking for a template of a consortium agreement. If you be so kind to share one with us.
I would try because the agreements, as you can imagine, that I will have are subject to client confidentiality.
Yes, definitely.
Yeah. So exactly. So maybe if I'm able to sort of what's that word we use to sterilize? Yeah, that's the word we use to sterilize.
Or anonymize.
Sterilize. So so the document is just plain and all that. No parties reference and all that. Oh yes, I think I should do that. And I'll share that with you at the Aditola at some point.
All right. Thank you so very much. And on a lighter note, Alimat says she's an admirer, so
okay. Thank you so much, Alimat. Thank you so much.
Okay. All right, I will be handing over to Mohammed now. Mohammed, over to you for the closing remarks. Thank you very much, Folashade. Thank you for your time today.
Thank you, Aditola. And Aditola, just say you look really familiar. Looks like I've seen you somewhere.
Really?
Absolutely.
Oh wow. Maybe it's in Lagos. It's in Lagos.
Yes.